Good Monday evening, everyone, from the law firm of Shihab, Burke. My name is Sam Shihab. I'm an immigration attorney with the firm, and with me,
Brian Burke, from that very same place.
Yes. Every week we spend a little bit of time to talk about a topic of interest. Today we're going to talk about overcoming family-based adjustment of status denial. Now, while Brian, it applies to spouse cases, other family members, it also applies to employment when there is a spouse involved.
Yeah.
Because when you file an adjustment of status and then you're also applying for a spouse, this also can be very relevant. So it really encompasses a lot more.
Yeah, I mean, we're talking about a lot of basic principles here that apply across all types of green card cases, for sure. Yeah.
So let's set the stage for everybody to understand what we're talking about here. We've spent a lot of times in videos, Brian, talking about how to prepare the perfect adjustment status application, how to prepare for your interview. We're not talking about that today. We're talking about you've already filed your petition. You've already went for the interview, and you walked out of the interview and you didn't feel very good.
Yeah.
You felt that there was a mismatch. Something happened. You couldn't answer the questions properly, and you feel, or you have already received, a request for evidence, an RFE, a notice of intent to deny, which we call a NOID, or you received an outright denial, and now you need help. Now at this stage is what we're talking about today. You were unprepared for the interview. You did not keep a good record. Of course, you're not writing. You're answering. The officer is writing.
Yeah.
And you are at a great disadvantage as a beneficiary in a scenario like this. Make no mistake about it. You are going to rely on the notations that the officer wrote. You did not take good notes because you couldn't take good notes. You do not remember everything that went in that room. You're foggy. The whole thing is just a cloud of confusion, the way things went. And you receive this document that has a lot of stuff in it that is overwhelming. Sometimes these documents are 10 pages long, typed, that has a lot of stuff. So we're at this stage, as lawyers, get involved to help clients resolve their issues. And the first question you ask yourself, what really happened? What caused this denial? What caused this RFE? And the reasons can be broken down to a few logical scenarios. One of them, the officer doesn't like you.
Yeah.
The officer does not like you, and they were tough on you. Let's face it. We encounter these. A lot of officers are good officers. There's a good number of officers that are not good officers. And you felt that you were not really treated right. And that's where we get involved to get things resolved for you and cleaned up for you. You could have missed a very important evidence. Things that are, the file, you thought you included it, but it's not there. Could be the financial sponsorship documents were not complete, and these are complex, and we're going to spend a moment to discuss these. Or the evidence regarding the relationship were not really clean.
Those have the opportunity to really generate those 10 plus pagers for sure.
Yes, and not only that, but those individuals or applicants who are not in a profession that requires a high level of precision typically tend to be more foggy. I personally feel that women are a lot more detail-oriented on these things than men. Just the way they are, they remember a lot more details, and sometimes that can give a misinterpretation that that there is maybe something fishy about the relationship. There could be legal issues, admissibility issues, criminal issues, or the petition is just messy, sloppy filing that was not done by a lawyer or a good lawyer, or you've done it at home, and it's just the byproduct is nasty and it doesn't look good, and that created the denial or RFE or the NOID.
Yeah.
Be that as it may, you come to us and you need help. The first thing we tell you, Brian, is read it carefully. Read the document carefully. USCIS works off of a template. So they begin with a template and they fill the gaps, with some information. So not everything in that RFE, in that NOID, in that decision really very helpful or relevant to you.
There's some cases where, if they don't want to deny on a very technical issue, like maybe you didn't give them the right financial evidence, they're going to issue something that's sort of, the same thing they gave to the last person they denied on this issue, and that's that. But sometimes you do get one where, they spent a lot of time on you. Yeah. We sent somebody out to investigate you at your home. We pulled your tax records. We pulled your car registration records. You just have to read these things very carefully because they're just so different each time.
One thing we need to tell everybody that you get one chance at this. A NOID, notice of intent to deny, or filing a motion to reopen, to reconsider, is a 30-day window, and a lot can happen within this 30-day window. USCIS sometimes issues something called an NTA, notice to appear, which refer the case to deportation, and that really shuts down the door down on any opportunity in most cases to come back and fix this. But if you put together a quick, considered response, you could potentially change the direction. And honestly, a lot of cases do change direction in a positive way if it's done correctly.
On an RFE or a NOID, yeah. So, this is a presentation about denials, and it just, like we said, you can avoid denials by doing good work on RFEs, but sometimes denials happen, and I guess we move on to how do we attack a denial.
Attack is the word.
Yeah.
And that's an important word, Brian. Attack it, right? You got to attack it.
Yeah, no, the attack metaphor works because as soon as I start working on an appeals case, I'm like, okay, who's going to be in my army and what kind of tools, what kind of weapons are we going to have to go after this decision?
Yes.
Right? So, first of all, again, there's probably all sorts of great war metaphors wrapped up in this. First of all, you have to act quickly. As said earlier, just for RFEs, you might get 87 days. For NOIDs, you get 30 days. And for most types of appeal with USCIS, definitely anything in this category, you get 30 days to respond.
With RFEs, is maximum 87,
maximum 87
but you
days.
Could get 30 days as well. Yeah.
So you get 30 days to make your motion or appeal on a case, and I can tell you that sometimes, especially with the very complex ones, that's a very tight window. So if you have a denial, you cannot sit on that. Anytime, if somebody comes to me with, I have 2 weeks left on my, motion or appeal, that's 2 weeks I didn't have to basically do as much as I can to overcome it, for one. So when we're talking about attacking these things, people ask me, when we're doing a consult, for example, on a denial, well, what are we going to do, right? Well, the way I'm writing one of these and the way it kind of has to be on every case is there's sort of two fundamental things going on here. There's legal attacks and there's factual attacks. So on the legal side, you can argue with the government as to whether they've done their job properly. Government, all the facts out there are right, but you came to the wrong conclusion. Or maybe they didn't follow the process. Did they send you an RFE on this issue like they were supposed to? Did they explain to you that, that your response that you said on the RFE that wasn't perfect, that if you didn't give them a perfect response, that they deny the case? You can attack them about the process, and that could be as good as attacking them on the facts. If you prove to the government that that they bungled up the case procedurally so badly, that can scare them just as much as a bad factual conclusion. Speaking of the facts, if they say, we got you. We don't believe you're married to your wife. We think you're living in a different spot. We don't think your names aren't on the lease together. All those things. We investigated. We went to your home. We saw your home, and we don't believe there's two people living there. All those things like that. You can come up with facts to overcome that. And the answer is, how do you address it? First of all, you leave nothing on the table. We always have to explain to people, this isn't, especially at the appeal stage, this isn't fun and games. If they deny this case, as you mentioned earlier, they have a potential, especially in this present climate, to issue a notice to appear, start deportation proceedings. And that greatly raises the amount of challenges that you have. And I guess the other thing you say is leave nothing on the table and give them absolutely massive amounts of evidence. What people don't understand is it's not enough to be right. Understand the government, they rely upon evidence. If they have a little bit of bad evidence against you, if you give them a mountain of good evidence, you can overcome that bad stuff no matter what the issue.
And the thing about that, Brian, and maybe turning the focus on the relationship evidence, or do you want to talk about missing documents?
Well, maybe we'll talk about, I think this is the one we'll go quick. I'll talk about missing required evidence.
Yeah.
So I think some of the most common denials and RFEs we see on family cases are missing documents. You didn't give me a birth certificate. You didn't give me a divorce decree. You didn't give me financial sponsorship records. You didn't give me translations. And you can overcome those. There's always a worthwhile argument to make about process, the government do the work properly. But fundamentally, if you have an RFE on this subject, you can overcome those by giving them what they want, right? Give them the document that you think is missing, right? So here's an example here, Sam. What happens if I gave them a birth certificate and they sent me an RFE or a NOID or denial that says, well, we didn't get one. We didn't get one. A pretty common thing. And what people need to understand is that people come to me and say, Brian, this is an easy one for you, super easy one. I sent them my birth certificate. They said they didn't get it. And the answer is no. This goes back to reading that decision notice and kind of knowing how they write them. They work, as you said earlier, they work from templates. If they say, hey, we didn't get your birth certificate, odds are they did get the birth certificate you sent. They just didn't like it. And they're not good at explaining to you why the birth certificate you gave them is wrong. And maybe you didn't read the RFE very well. So you can overcome that by basically, especially if an RFE, you give them a good response. But if you're at the appeal stage after a denial, you have to come at them full force. It's you get a replacement if your document's wrong, and you explain to them, why that your document you gave them probably was good. Similar sort of issue with financial ability. Say, well, I gave them all the evidence they wanted. I gave them my tax returns and my W-2s. How can they deny me on this? Did you really understand the requirements? Just because you give them the evidence they asked for doesn't mean you meet the financial requirements.
And the requirements are intricate. I mean, it's not straightforward.
Yeah.
We pause and look at it sometimes and say, hey, do we have everything we need?
Yeah, so on these missing evidence cases, I would say, people ask me all the time, what's the prognosis? Can we overcome something like this? So it is a scary immigration climate out there, but USCIS is usually willing to take a solid, appeal on a case like this. It's I didn't give you what you wanted, here it is now. Here's a good explanation. They're willing to take those cases, and we're still seeing good results on them.
Yeah, absolutely. The relationship evidence denials. So now, remember, when you get a denial from USCIS on a case or you get an RFE on a case, they're going to attack you on all fronts. They're going to attack you on the legal front, they're going to attack you on the factual front, and they're going to mention a bunch of different things. It's not going to be only one thing or one category. They're going to attack you on the potential visa, whether you're on status, or they could attack you on you didn't provide all the criminal record, and then they're going to attack you on the relationship evidence perhaps.
Yeah.
But there is always the big one. There's always the big one. So there's one big one usually that's really the heavy one, and then there's the other small ones that really can be resolved easily. Oftentimes the relationship evidence, Brian, is in the center of a spouse denial or a notice of intent to deny.
Yeah.
And normally not enough evidence. People say, well, we got a joint address, we have his name on the lease, we just created a joint bank account, we have a joint car insurance, and well,
it's a good start. Yeah.
That's the appetizer.
Yeah.
That's the appetizer.
Good start. Yeah, it's an appetizer.
Yeah, appetizer. That's not the main course.
Yeah.
The main course is digging deep into evidence and details, and that's when the evidence they either extract it from you during the interview, or evidence you submit, pictures. I always say a picture is better than 1,000 words, and give them 30, 40, 50 pictures. They love to look at pictures. Not in the same event, not in one party, 40 pictures, that doesn't help. It spans the time. Everybody get an iPhone. Everybody takes selfies.
I always tell people, I want them to see videos of, you with a beard and you with 6 months ago with your hair, 10 feet long.
Yeah.
A variety of first time where they can't really question it so much anymore.
And what USCIS does in the relationship evidence is they say, well, we ask this question, you said this, she said this, they're different. We ask this question about when did you guys meet? You said this, you said that, and they're inconsistent. Yeah. And we must reconcile this inconsistency. Now, to the extent that that's not what you said, and the information they provide, you can provide an affidavit to correct it. But if there was a misunderstanding, you have to correct it. And I have a couple of them here to kind of highlight the home layout. I grouped them those in big. The home layout questions. You know.
Who sleeps on what side of the bed?
Yeah.
How many chairs around your kitchen table? That sort of thing.
Yeah. So whose side of the closet is on the left when you walk in? You know, is on your left. One says it's on my left. The other one says on my right, and they say but these are, in my opinion, my humble opinion, these are stupid questions because these are simple questions, and it is clearly confusion questions. So if you're looking at it from walking in from the bathroom, let's say there's a bathroom that's inside, and you walk in from the bathroom into the room on one side, but you walk in from the outside, so that flips the orientation.
Yeah, my favorite is who sleeps on what side of the bed?
Yes.
Well, I sleep I'm on the left if I'm in the bed, but if I'm looking at the foot of it, I'm on the right, and those officers are very happy to accept inconsistent answers on questions like that.
Yeah. What did you have for dinner? Okay. One person says I cooked, the other one says I ordered in. Well, it could be that one person worked late and ordered in at work, you know, and the other person cooked, and they didn't have dinner together, but this is not understood to be, so that can be resolved. Who sent the first message, and what month, and how did you guys meet? One says, we met together at this place. The other one says, at a party a week before. Well, it could be meeting could be, I don't think I met her, we just talked in the party, but I really met her in the other event. So explaining these differences requires, what does it require? It requires a statement clarifying, and then also other evidence, from friends that talk about how you met. Well, yeah, they were at the party, but I don't think they've talked to each other, things of that nature. So you got to do this relationship evidence detail, routine life, how did you meet questions. These are the typical ones. Wedding detail questions always, they were at the wedding, man, here's the pictures. So, okay, one guy does not remember how many people were there. It doesn't remember. It's an overwhelming experience. What are you talking about? Now the marriage is not bona fide. Here's the picture, they're together. It's irrelevant. So it does not give rise that the marriage is not bona fide because somebody did not remember the number of people at the wedding.
Well, Sam, you sound like a good attorney. You sound like you believe your client, and because your client's here with you, and they're saying, "But I'm married to my wife. I love her.
Yes.
I don't want to be separated from her." But suddenly, in the mail, you think you did good at your interview. You get like a 10-page,
fee.
She said this, you said this, she said this, you said this, she said this. Plus, we visited your home. We visited your home. We talked to the apartment manager. They don't recognize your wife. We talked to your neighbors. They didn't want to talk to us. We looked up your car registration. She's registered at this address. You're registered at this address. All this evidence. They spent tons of time on you, and you're sitting there twiddling your thumbs, and you get a nasty letter in the mail. What do you do?
Yeah, and you're shocked. So what you do, Brian, for everybody that's listening, is you take every fact, every one, you break them down, and you start with the heading. Discrepancy about when we met. Another page. Discrepancy about the number of people at the wedding. Discrepancy about, and then you start by 1, 2, 3, 4, what do I need? And you build your case. What evidence do I need? And you build every case about statements from third parties, affidavit explaining it, picture, logical counter argument, the color of the door. One said green, the other one said off green. Well, when the sun hits it in one direction, it's one color. When in the evening, it looks like a different color. So what do? You take pictures of the door in different angles.
Yeah, see, you're giving them the benefit of that being a different answer. That's one where, I'm going to be the guy, bull. That's bull. And part of, going through one of these is sometimes somebody will show us one of these things, and my sort of human instinct kicks in and say, 10 pages, they say all these things. But when you carefully read these things, you'll find that, the things that they consider to be issues are just sort of, how is that an issue?
No issue.
Yeah, no issue.
Remember, how not remembering the number of people in my wedding, which I've given you 10 picture
he said there were
I'm
9
there.
people at the wedding. She said there were 10 people at the wedding. You know,
Or 12.
Yeah, margin of error.
Especially
like
with the number is large, 40 and 45. You know.
Yeah. So these big ones are incredibly daunting, but they can be overcome by basically, like you said, going through them. What we do here in our office when we have one of these things is we will sit a couple of attorneys down and basically talk through this, talk about, what did they say, what does our clients tell us, and typically that aligns with what is reality, and we talk about, well, how can we prove it? How can we prove that what they're saying, what the government is saying doesn't make a lick of sense, and overcome it, because evidence is so important as well,
Absolutely, Brian. The thing to remember is you do not overlook any of them or gloss over. You got to address each and every one. Each and every one.
Yeah.
All right.
Because they do think that they are absolutely putting out, grade A work every time they put one of those out there. And
by the time we are done countering them, we should, for everyone that they state, there should be at least half a dozen of evidence refuting that statement, putting it into question. All of a sudden now, their house of cards start to fall.
Oh yeah, I mean, in immigration, the standard is the preponderance of the evidence, and basically you have to show more likely than not 51% true, right? And if they have these tiny little issues, and you got affidavits from family, photos for the last three years, you can overcome them. You can make their evidence look small, you can overcome them and basically scare them into approving a case.
Yeah. What about the financial sponsorship problem, Bob?
So we talked about this a little bit, it's a little bit of missing financial evidence. Financial sponsorship problems are probably the most common issue on I-485s. And this is, I-485s, adjustment status applications in the United States. When people come to us and say, hey, I got my green card denied, if I were a betting person, I would bet it's on the issue of financial sponsorship. I would say high level, there's a couple ways that people fail on this. A lot of times people just forget to give them the financial ability stuff because they got a solid guide online and they just filed it and they forgot about the financial ability stuff. So if you don't give them the financial ability stuff, you're going to get a case denied. But if you don't understand the requirements, you can't just give them the taxes and say, yeah, I'm good. You have to basically understand where they publish their financial requirements for a green card application and make sure that you're able to document your ability to do it. And if you have an RFE on this and you're confident, sure, give them the evidence that you're right, they're wrong. But when it comes to an appeal scenario, again, one of our sort of general theories about appeals around here is not only make it clear that they're wrong, make it super easy for them to approve the case. So if somebody comes to me and says, Brian, no, I have all the requirements. You just have to gather every piece of financial evidence from my life, and that shows I have the financial ability. I'm going to say, cool, but you're trying to get them to approve your case, and you want to do it as easy as possible. I will make that argument for you if I have to. In fact, that's going to be argument one, that everything you gave was already good enough to show your financial ability, but make it easy for them. Make it easy for them. If you have a problem with financial ability and there's an alternative way to solve it, like getting a joint sponsor, do that. Make your RFE responses and appeals easier by giving them more than what they want, because fundamentally, they're honest. If you give them good answers, they will approve a case, but you don't want to leave things up to chance. Because again, if you don't respond in a satisfactory way to an RFE or annoyed, they'll deny your case. And if they've denied your case, you have 30 days to respond. Otherwise, you're probably looking at an NTA and deportation proceedings in this current climate. Yeah. Not pleasant, for sure.
Unfortunately. All right. So in May of 2026, and I want to mention that so people can put a time reference to this, USCIS issued a policy that says the whole idea of changing your status to a permanent resident in the United States through the process called adjustment of status is an extraordinary relief, and it's an administrative grace. And come out with language that says, really you should leave the country, or your wife should leave the country and should stay apart from you for a good part of who knows how many years until the consulate has the mercy to meet with you and give her the right or him the right to come back to the U.S. And then become a permanent resident. Number one, the prevailing opinion on that memo that it is highly not legally proper, because a lot of this language are pulled out of the deportation context when you apply for an adjustment relief in the deportation hearing, which is a completely different sphere of type of cases than the cases when you apply for adjustment from if you're an H-1B visa or an F-1 visa or somebody who's entered legally in the U.S. So there's a big question mark. And also there was an exclusive article released by, I believe, the Washington Post, or I think the Washington Post. I believe, or
the Wall Street Journal,
or the Wall Street Journal. I read both of them.
You love sending me Wall Street Journal links, and I don't have a subscription.
Okay,
so.
I read both of them, so I'm not sure where it came from. Where the unspoken word is this thing is really on hold, but we'll cover it today to make sure that we're on the same page. So, what USCIS is asking is you must show positive factors.
Are you the sort of person we want to extend that grace to?
Yeah,
right?
Positive factors for USCIS to exercise their administrative grace and exercise their extraordinary form of relief and give you an adjustment status approval. And we will include those in the adjustment because we're not here to fight with USCIS if they can give us an approval, but it's always good to cover all bases, notwithstanding the fact that they're illegal. So what are these discretionary factors?
There's a list that's like, maybe 15 bullet points long. And I would say a lot of these things don't apply to a lot of people, but, ties to family members of the United States. So if you have, 3 U.S. citizen kids, a U.S. citizen spouse petitioning for you, and you're the only member of your immediate family, like, brother, sisters, and parents who's not a U.S. citizen, that's a factor that you might want to bring up. Obviously, potential hardship is a big one. If you're in a spot where you've overstayed a visa, and if you leave the country, there's certain rules that might force you to be barred for 3 years or 10 years. The fact that you're going to be separated from your spouse for a decade might be something that you would consider.
Exercise administrative grace.
Yeah. If you're well employed, if you're well educated, if you're paying your taxes, if you have a criminal history, otherwise complying with the immigration laws, things like this.
Anti-American views.
Yes.
I don't know. What's anti-American views? If you, we're not going to go there, I guess. But it's an eye of the beholder, right?
Yeah.
All right. So I don't think this is going to be a big deal, but it could be a scenario. A lot of those things they say, well, we're going to deny you because we're not going to exercise administrative discretion to grant you adjustment of status because you're otherwise eligible, but we're going to exercise the discretion not to do that. These are appealable for abuse of discretion.
Sure.
And if they do that, they're going to be having a lot of cases in federal court on appeal.
Yeah.
Because people are not going to leave.
But still, I want to, even though I agree with you, what I'm telling people right now when I talk about doing adjustment status in the United States is that policy's out there. It hasn't been rescinded, but it doesn't seem like they're really sort of enforcing it. However, if you sort of, look beyond the immediate issue in front of us, clearly they're putting more scrutiny on cases in general, and that includes, family, employment, and it's worth bringing up a couple of these things out there. One is there's all sorts of talk about them using AI to review cases. So that's out there, comparing your answers from one case to another, one filing in the past, that's something that's out there. There's sort of enhanced vetting out there, a very sort of common trend that I'm seeing is when I'm going to green card interviews now, far more likely that my client's going to be asked about not the green card application they submitted, but whether it's consistent with the visa application they submitted when they came to the United States as a visitor or student or H-1B, 5, 6, 7, 8, 9, 10 years ago. That's out there, and that, but in 1,000 different ways. I trust them what they're saying, even if not this memo itself, even that doesn't stay around. Trust them what they're saying generally. They're putting more scrutiny on cases, making it more difficult to get things approved.
And we're seeing more denials that we are filing motion, and we've had great success.
Yeah.
Touch on wood, but So this is a serious issue, and if you feel that writing them a general letter is describing how much you love your wife and expect to get the result, that's not going to happen.
Yeah.
This has to be a full press. Typically our responses are that thick in documentation. They will get more paperwork that they have time to go over, and oftentimes that will change the tide in the right direction.
In terms of volume and quality evidence, is just one last thing I want to bring up. We were talking about this before we began this presentation. So, if you put together a sloppy case, a case where your answers to your questions aren't accurate, your evidence is sort of weak, keep in mind, you're not just competing with yourself, you're competing with, cases. If this officer looks at cases that are drafted by attorneys or better put together cases, if they don't really have a great idea as to what, preponderance of the evidence means, how much evidence is needed, but if everybody else is putting together a much more organized, much more thoughtful case, and yours is in there, it can be a real challenge from them. You don't want to be the low man on the totem pole. You don't want to be the person who looks the worst, even if though you're probably meeting the standards. If everybody looks better from you, they have to go after somebody, and it's going to be you. And this is a frustration for us. Is we will talk to people who have done their cases themselves, and they kind of get railroaded during interviews because they don't really have the benefit of kind of knowing what to expect and what the government's really looking for, and it hurts them.
Yeah, and this is an expertise in the way you prepare and handle these cases. The attorney has to have the patience, the wanting to go into very minute details and go through everything to prepare a very detailed response. Anything less than that, you're taking a big risk because you only have one chance. All right, Brian, so we've taken half an hour here. Let's take some time and take questions from people. People are patiently waiting here, see if there's any questions, and let's take that.
Oh, we have a lovely amount of them. So
let's jump in, and then if we don't have time for the to take question from immigrationquestions.us. So for everybody to understand, immigrationquestions.us, questions you drop during the week, we will answer them. And I know, and then below is Shihab. On the YouTube. You can post them live, and
we'll get to some of those live right here.
Yeah. So
YouTube, we'll take some live questions right now.
Yeah.
Immigrationquestions.us is a website where you can shoot us a question during the week, and we'll often get to those here. And if there's something that we don't get to here, we will usually try to address those via email when we can.
Yep.
So, got some questions here live, some classic employment-based questions. Initial I-140 EB3 India. I-45 concurrently filed in EB3 India, October 2020. TUB filed back to EB2 in 2022 per USCIS guidelines. Case went silent. Now got I-693 RFE for whole family. Does it mean I'm still in EB3? So, my best answer is I would suspect that USCIS is not really thinking about where you are right now. But if you made a request to TUB to EB2 and it was done properly when your final action date was current, you're in the EB2 category. Because TUBs have consequence. There are legal rights attached to TUBs. Yeah. Like the restarting of the 180-day portability period, for example. Whether the USCIS whether the officer reviewing his case knows that he is not eligible in EB2 right now and can't be approved in EB3 because he tubbed is another question. And that's the answer is maybe you send a tubbed letter that,
There's no good handle on where you're at.
Yeah.
So whatever category you want to be in, you want to push it, you want to file.
When your party gets current, you remind them that you're current in that category and they can approve you. Yeah.
My priority date is 2023 EB2 India. Filed EB1A May 2024. It has crossed 2 years now, still processing. What would you recommend? Do I wait while the visa bulletin may move forward in October? What do you think, Brian?
So is this a pending EB1A? It's still pending? Still in process with USCIS?
Yeah, it looks like it. For 2 years?
That seems like a really long time for.
Makes no sense.
I haven't seen the processing times for. I'm inclined to look them up right now, but USCIS processing times for an I-140 and EB1A category, it's got to be shorter than 2 years.
Yeah.
I will tell you this. I usually file my EB1As in extraordinary ability. Here they are. Service Center Operations. 26.5 months is the quoted processing time.
Right
so, fun fact, I don't know those because we usually file ours in premium processing. And the answer is if the processing time is 26.5 months, you might hear something soon, but heaven forbid you get an RFE in this nasty RFE-laden climate, because then you'll give them an RFE response and they'll still won't have a time frame.
I mean, if you're current, I would upgrade to PM processing, try to push it. If you're not current, you have to weigh in pros and cons. Is your job, are the facts underlying the EB1 still solid? You want to save the money, so there's,
Yeah, I think I'm kind of on that front. I mean, if you think your EB1A case is approvable right there on its face, yeah, upgrade to premium processing. Sure, if you're a superstar scientist with 5 patents, 30 published papers, big awards, and everything else, sure, why delay the approval of your case? But if you think you might be marginal before upgrading to premium processing, think about what that RFE is going to look like, and think about how you're going to, flex your muscles to get it approved.
Yep. All right. H-1B entry February 25, filed L2 June 25. Okay. Filed H-1B transfer December 25. Started working under portability rule. L2 was approved on June 8. Then H-1B transfer was approved on June 18. Listing.
Let me see here. Hyderabad Consulate notice.
Okay.
The H-1B approval text shows starting validity of June 18, 2026 instead of December 25 filing date. What official immigration status was I holding during that bridge? And again, there's more of it. Gap from December 25 to June 18th, 2026. Now the L2 is approved in June 8th and H-1B approved via concert notice.
I honestly, when situation like this, I tell people, bring me all the documents.
Yeah.
I don't think I can answer that question in good faith and give you, that's kind of I got to lay out all the documents and I got to go through it in full detail instead of giving somebody what status. But if the H-1B was approved
for consular
notification, you're now
the answer was never H-1B.
You're now on H-1B. And if the L2 was approved with an I-94, likelihood that you are on L2, but again, I got to look at the document.
Yeah, I think we only fundamentally agree that if the H-1B is approved for consular, you're definitely not on H-1B ever.
Yeah. And that's not good news because obviously you know how much money they need from you.
Yeah.
To get you back on H-1B.
Yeah, until that court case works out, which maybe will happen later this month. Yeah. So I think we already answered that one. Sometimes people like to repeat these questions for us, and I think so. We covered the things that we have live on YouTube right now. Maybe we'll take a moment to check out what our chums and friends are telling us by way of immigrationquestions.us, and I'm going to pop it over in this monitor here while that thing loads. I'm going to take down this question, and I'm going to wait for immigrationquestions.us to load up for us. And I will remind everybody that is our website. If you send us a question through immigrationquestions.us, we will not read your name and email address here, but we will also try to give it an answer. And sometimes it's a little bit of fun to get questions at immigrationquestions.us because you can put in a lot more information from us here.
Yep.
And here's one we've got here right now, live. A great sort of question here, and I'm going to see if I can fit it in the live thing here. Hey, I can, loving it. When applying for EB3, unauthorized work has happened before last lawful entry on F1, but now on H-1B. How do you invoke INA 245K, or is it automatically applied? Also, does it erase it, or does it forgive the violation? Thanks. A great question.
So, let me get this thing right, Brian. So when applying EB3 and an unauthorized work has happened before last lawful entry. And so it happened.
Somebody was on F1 status, yeah.
During F1, then you left the U.S.
Yep.
Then you re-entered again, and now you got on some kind of a work visa, L or H visa or whatever, and then now you're applying for EB3, and now you're saying, how does that unauthorized employment that happened a long time ago applies? And the answer, it doesn't apply.
Yes.
Because
INA 245K only cares about your status violations since your last entry to the United States, your last lawful entry. Now, I have to give an asterisk on that in the following, that there's a missing piece of information. So somebody is saying that when I was on F1 status, I had some unauthorized work, and then I came back. INA 245K saves me, right? And it saves you from the unauthorized work because it's during a prior visit to the United States. However, I have to ask the question, how did you get back to the United States? If you had a valid visa and you use the same valid visa, sure. But if you got on a different visa when coming back, if you left on F1 and came back on H-1B, and you completed the DS-160 that says, I've never worked without authorization in the United States, that's something you didn't disclose, and that's something that can make them say, but INA 245K does not excuse fraud or misrepresentation in getting an immigration benefit, and that's where there can be a problem.
So how you answered on the DS-160, because they're looking at the DS-160, because there's a question about unauthorized employment,
Yep.
can be a different type of problem than the INA 245K. However, this is however to the however.
Yeah.
However, if you think that you have that scenario, you need to talk to counsel because there may be ways around it.
Yeah.
That's all I can say.
Yeah. I guess I would, how does it come up? You get asked a question on your I-485 that says, hey, have you ever worked without authorization in the United States? And it doesn't say since your last entry. It means ever. So even if there's a scenario where you didn't disclose it, where you weren't required to disclose it any time in the past because there was no questioning ever from the government, you do have to disclose it at this time. Otherwise, they will get you. Well, yeah, exactly. Yeah.
And obviously, you may have a different issue because if you stayed in the United States for a year and a half after work without authorization, you may have you have had a long time of not being in status.
Yeah.
But those are complicated questions. But that's trying to kind of touch on some of these.
Yeah. So let me see here if there's any fresh ones here. I don't think there's any fresh ones here. I think the freshest question we have on immigrationquestions.us is from, well, maybe see if we have any more live ones here and we'll maybe call it quits. I don't think we have any fresh ones here.
Good, excellent. Yeah. So 642, hopefully you guys benefited from that presentation. And 6 o'clock next week, we'll come out with a different issue. And if you have any things that you want us to talk about, drop it in immigrationquestions.us. We'll be happy to do it.